It looks like Mr. Azultine, I may be pronouncing that wrong, had a fairly recent warrant. I would be we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
Welcome back to Judgment Unfolded, where real courtroom moments meet sharp analysis. Today, we're diving into two back-to-back hearings where defendants try to outsmart the system with sovereign logic. From declaring themselves living men to denying jurisdiction entirely, both cases descend into chaos until the judges step in with calm authority and controlled disbelief. In the first case, Mr. Result refuses to identify as a defendant, claiming he's a living puhan.
Before I feel comfortable with this court moving forward, has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, but rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator, and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yeah. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth, and if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Here we go. The sovereign script kicks in. He instantly disowns the name on the case, calling it a corporate entity, a classic move to dodge the court's authority. But it holds zero legal weight. These self-made affidavits of truth are nothing more than paper fantasies. Judges have seen this act countless times, and the moment someone declares, "I am the living man," you can almost hear the gavel tighten, because everyone knows it's about to be a long morning.
Number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the...
Mr. Mathis, today's the date and time for your informal hearing. Invitation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, near Washington, in the City of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr.
This is where the judge's patience becomes pure skill. She doesn't engage with the nonsense. She stays locked on one point, confirming the defendant's identity. When she says, "If you're not the defendant, you're a spectator," it's calm, controlled, and razor sharp. A firm reminder that courtrooms run on facts, not fantasies. It's professionalism at its peak, one side playing by the rules, the other lost in illusion.
Mathis, you have three options, and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine, and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have.
And there it is, the mute button, the ultimate equalizer in Zoom court. Judges only use it when order completely breaks down, and this time it did. Mr. Island's refusal to confirm his name leaves the judge no choice but to strike the hearing and keep the warrant active. The message couldn't be clearer. You can't outtalk or outwit the law. Courtrooms run on clarity, not creativity.
Be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge black in color with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
Without missing a beat, the court moves straight to the next case. And surprise, it's the same script with a new face. This time it's Anthony Winston Mathesy, proudly declaring himself the living man here in special appearance. If the last hearing felt bizarre, this one cranks the absurdity to a whole new level.
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the
The judge delivers a masterclass in patience and control. She lays out three clear options: admit responsibility, admit with explanation, or deny responsibility. Instead of answering, Mr. Mathesy declares he only pleads to the Most High. Classic sovereign rhetoric, turning law into spiritual theater. But the judge remains steady, calm, and unshakable. She repeats the process, reinforces structure, and keeps the courtroom grounded in law. This composure is why seasoned judges never lose control. They've heard every version of "I don't consent" before.
The court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
under
the Motor Vehicle Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any...
And here it comes, the classic, "Where's the injured party?" argument. It's the hallmark of sovereign confusion in traffic cases. There's no injured party because these aren't criminal harms. They're administrative violations. The city of Royal Oak isn't a person. It's a governing body enforcing road safety. The judge explains this with crystal clarity, yet the defendant keeps chasing a phantom that doesn't exist. This moment perfectly exposes the gap between belief and law, frustrating to witness, but fascinating in how predictably it unravels.
Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
And there it is, the final ruling. The judge finds Mr. Mathis responsible and issues a $175 fine. Simple, fair, and by the book. But the real takeaway isn't the fine. It's how both defendants refuse to engage with a process meant to help them. One could have cleared a warrant in minutes, the other could have settled a minor ticket, yet both chose delusion over logic. These hearings prove a vital truth. Knowledge of the law isn't power, understanding it is. Judges don't win through emotion. They win by mastering procedure.